So, good evening, everyone. I hope I'm very loud and clear. Thanks for joining the most discussed area of this year and last few years. That is the data protection bill. And I mean, last Friday when we received the new draft bill, there are a lot of questions from the various people regarding how to interpret the new bill, and which is definitely when it comes to the simplicity in terms of the it's very leaner from the last bill to this bill, but at the same time what I understood that there are little some areas we need a little more clarity in terms of whether it is how to interpret certain clauses which is mentioned in the bill. And definitely when I look at that, the first foremost important thing is I can when I am looking at the bill, it first thing comes to mind. Hey, it's so simple, right? I mean, it's earlier it was like 99 sections, and now it has become almost like 99 to 30 sections now. And also there is previously they focused on mostly like the personal data as a overall, but nowadays in the new bill it is mentioned like digital personal data, and not much differentiation between the non-personal data, anonymized data. That is what earlier bills talked about. And also there is a earlier bill it mentioned about some sensitive data and critical data, but now it is like personal data only, digital personal data. And also, I mean, definitely the penalties clauses have been changed and some exemptions are given. And also the what I can see as a business point of view, the last bill actually there are a lot of discussions over the cross-border data flow requirements, and so many business. I mean, larger. The multinational companies have some kind of um, resistance to adopt that bill because of restricting the data from one country to another country. So that is one of the biggest thing happened in last bill. Apart from that, yes, there is a lot of discussions happened. Who is supposed to, who is responsible for ensure the enforcement, and as well as the kind of the protection, protecting this data in terms of how to hear from the data principals, their concerns, the grievances. So there is a lot of things that happened, but overall, I would say yes, it is. It is very simple to understand now, so because I walked through that. But however, when it comes to the interpretation, and there are certain areas, definitely we need some expert, opinions to understand, little more in a deeper level. So when I thought about the privacy expert, I can only, only one person I know. We are closely working with him. He is none other than Mr. Navi sir. Actually, people call him Vijay Shankar, but he is known as a Navi sir. So let me give some brief. Just I know a lot of people who are joined here. They know him, but since I want to introduce himself, Navi is a pioneer in cyber law and data protection things in India, and also is an ex-banker with wide experience in marketing, merchant onboarding, merchant banking, and information security areas. And also he is well-known person in the privacy domain, because he is author of so many books, and also a very thought leader with innovative concepts, such as he's written a books on so many things, like innovative concepts like personal data protection standard in India, whether it's a data visualization standards, and data valuation standards, and as well as the data trust scores. This is one of the recent period we underwent some kind of sessions with him, under him. So he explained so very well in our data protection summit happened last week. So it will become after our summit. Actually, the bill is came. Otherwise, it would be one of our major discussion point in our privacy week. So, however, now again we got another chance to discuss about this the new draft bill. He is a qualified independent director certified by IICA. So with this, I would like to have, I mean, a lot in between. Navi sir, actually, when this draft bill came, I mean, published on Friday. So in fact, you don't believe, on Sunday itself, I got different calls and some messages. Uh, can we arrange some kind of a session, because everybody eager to understand how this new bill, I mean, how it actually impact really. They want to understand the main differences, but that is apart from that, how the new bill really protecting the main the main intent of this bill to protect the data principles, right? How we can protect their rights. So a lot of people asked me to arrange some kind of a session. So that's where actually I requested you. Thank you very much for accepting our invitation and join this webinar. And definitely, we would like to understand from people like you how you look at this, the new bill. So I already, when I mentioned, yes, we are conducting some kind of the understanding session, more deep dive into this protection bill. So we got some couple of questions also from the various people. Okay, so the first and foremost, I would like to understand from you, as far as here the new bill talked about data protection board. That is the main thing they mentioned there. This is the authority. They have the kind of responsibilities for enforcing this bill and also penalties. But at the same time, most of the control will be laid with the central government or the governing body, So how you would look, I mean, this change, I mean, is it really, because data protection board is one part of it's a kind of a civic body, you can say a regulatory body, but at the same time, there is above them, there is again the government coming into the picture. That's what it seems to be. So how you will look into this change, how it impacts, sir?
So you have started discussions directly with the Data Protection Board, the regulatory authority. Okay. Basically, for people like us who are in the industry, maybe a lot of your participants are also from the industry, their concern would be how to actually be compliant. Whether it is Data Protection Board or Data Protection Authority, it doesn't make much difference for us if we are looking at it from a compliance angle. But still, the regulator is important because the consequences of our compliance or non-compliance will be adjudicated by the Data Protection Board. So we would like to know, what is this Data Protection Board? If you remember earlier, we had this Data Protection Authority, which would be having a chairman and 6 members. And it was stated that these members would be drawn with experience in cyber law, data protection law, technology, data science, and so on. All these details were available in the previous bill, PDPB 2019. Right now, no such details are available. Okay. Yeah. But it does not mean that the government will go for say 1+6, 1+10, or whatever is the number of members here also. And similar kind of credentials which were expected earlier may also be included here. So one of the things which you have to remember is, while the law has been simplified from 98 sections to 30, it is fine. It is easy for us to follow, at least at this stage. But it could be quite deceptive in the sense that a lot of subordinate regulations may come in the rules and regulations. Taking the DPB itself, now they have to somewhere state who is going to be the chairperson of that, what will be the qualifications, whether he will be like the CBC and others, an independent person who cannot be dismissed by the government. These are all things which have to be looked at when we are talking of the authority like this Data Protection Board, and whether this board will be consulting any private sector people, because even earlier the chairperson and the board was capable of having an advisory committee drawn from the public. I think even now it should be there. Otherwise, it will be very difficult for the administrators. The second aspect is, see, the Data Protection Authority has got administrative duties, plus they have got responsibilities for imposing penalties. So even in the earlier scheme, there would be an adjudicator. Adjudicator will be directly working within the Data Protection Authority, whereas there would be an appellate tribunal, which is a legal authority outside the earlier Data Protection Authority. And it was mentioned in detail about the functions of the Data Protection Authority, that they will lay down rules, regulations, they will have discussions with international organizations for adequacy and so many things. So all these things were specified as functions of the previous authority, which has not been specified now. But the same duties will be there even now. What they have mentioned in simple terms is that the Data Protection Board will monitor for the purpose of imposing penalty. So if they have to impose penalty, they have to keep monitoring the organizations. Now, whether they will go in for registration of data fiduciaries and others, we have to wait and see. Apart from that, they will be having this adjudication activity within the Data Protection Board, where, and also investigation. Say when they get a complaint, they can appoint their own inspectors. Those inspectors could go into different companies and ask questions and satisfy themselves about whether there is any violation. In addition, data breach notifications also come here. So data breach notifications come voluntarily from the companies. Inspectors also may get information from, say, market, from press about a data breach, and they also can immediately jump in. So either way, an investigation may start, and after the investigation, the board will take a view on the penalties. One more thing they have mentioned here this time, which is good actually for the industry, is that an industry or an organization can go for what we call as voluntary undertaking. What we mean by voluntary undertaking is, I think it is something like this plea bargaining. So an organization on its own, without waiting for somebody to point out that there is a data breach, there is a non-compliance, or getting a notice from either the Data Protection Board or certain, the internal management system, which would consist of a data protection officer or something, if they recognize that there has been a problem, there has been either a suspected data breach or something, they can voluntarily tell the Data Protection Board that I am sorry, this has happened in our organization, kindly pardon us with either no penalty or a nominal penalty. That's I think penalty. That facility has been given. So okay. If the companies are intelligent, they will use that. But of course, many of the companies will feel why we should actually come out with the revelation. But that will give one more angle for the authority to tomorrow increase the penalty.
Great.
See, we all say that once the breach is recognized, as soon as possible, it has to be brought to the notice of the authority. Most organizations will be dilly-dallying because they would like to know what are the consequences and other things, and there are other reputational issues. So unnecessarily delay will happen. When this delay happens, the authority will always come back to say that you delayed the reporting of the data breach, which would become an additional, you can say, non-compliance aspect. So voluntary undertaking is an incentive given to the organizations to ensure that the data breach happens without any nudge from any outside, without a press report, without something. Then I think it will be taken positively by the authority. I think this is one important thing in this Data Protection Board functioning.
Good, sir. Very nice. Very nice. So actually one more, I mean, there is another question what I will ask you last, not now. Now the very important element, the main change is like how you see they added the word called digital personal data. Earlier it was only the personal data. Now they're talking about the digital personal data. So there are where I'm reading some kind of blogs and everything. So how you can see this? I mean, is there any chance that if it is a like if I'm writing on the, I mean, I'm noting the personal details on pen and paper, is it not covered under the this particular bill? I mean, how you would like to see
Yeah.
this?
So this bill, they have very specifically stated that it is applicable only for digital personal data, which means that either the digital personal data has been collected online, which means that it originates in electronic form, or if it originates in a non-electronic form like paper, but subsequently it is digitized through a data entry, then that digital personal data becomes the subject matter of this regulation. Now, the paper document, if it has been used, now the question is, who is responsible for the security of the paper document after it has been digitized? Whether that will continue to be considered as a part of the electronic document or not is a question. Now here, of course, what the government thought was that if at all there is any law regarding protection of any property, like the paper document is a property of some kind. If it is stolen, if it is destroyed, there is the IPC or something like that. So what is not there is today the protection of data in electronic form. And in fact, if you look back at the, if you have any objection to this restriction, that objection has to be led at the feet of Supreme Court. Okay, because the Puttaswamy judgment, okay, they made a declaration that privacy is a fundamental right.
Fundamental right.
But they did not define what was privacy. They left it. They made a lot of in the individual say discussions of the judges. There were discussions of what is privacy, whether it should be called right to be left alone, etc. This is there in the what we call as arbiter dicta, that is discussions before the judgment. But final order, they did not define privacy. They only said that they also made reference to information privacy. See, they said that privacy is a fundamental right and closed the case. Okay. During the discussions, they also made a mention of information privacy. And now what the government is doing is, I will set up a statutory law for protecting information privacy. Rest of it is not of immediate concern, is what the government has said. Now, even if you take GDPR and others, see, if you have 99 articles in GDPR, maybe 90 plus articles are only on digital data. There is a reference to the filing systems, and only that filing systems is covering paper document. And only in HIPAA, sometimes we make a reference to oral information. If you see the discussions on HIPAA long time back, we have always been discussing that even oral disclosure of health information is considered as a breach of HIPAA. So, but subsequent GDPR kind of a things, they did not give much emphasis to the mode of, say, disclosure. They straight away went into saying that you should have privacy by design, you should have security, information security, and so on. So the emphasis was always on digital data only. Now, what government has done is they have taken that and then come up with this whole law, specifically talking of digital personal data, and also saying that it will not be applicable for manual processing specifically. So one way they have actually clarified their focus. Now, whether that is correct or not, whether they should have made this into a privacy act. This is not a privacy act. See, this is not a privacy protection act. That is first thing we have to remember. If it was a privacy protection act, we should have first defined a right to privacy is protected, and right to privacy in electronic form is protected like this.
Right.
So in fact, if you remember in whatever I had been writing, I had suggested that they have to do this because we were anticipating that the right to privacy will come into the law. But government, for its own, say in its own wisdom, have decided that let us not get into that. Let us directly go into protecting the personal data. Therefore, indirectly, it is protecting part of the privacy rights. I can say the privacy right which could be infringed because of the processing of personal data by third parties, that has been addressed in this act. Now, if that can be infringed by loss of paper documents or orally, that is not addressed in this
particular bill.
Unless that is also done digitally. Say today, if somebody makes a phone call to you on a mobile, what you get is not oral information, it is only digital information. Okay. So if there's a privacy breach of a data which is coming as voice, it is still a digital document. Second, Information Technology Act has got a very unique definition of data, which though people like us are saying again and again, had missed the attention of most of the industry people. See, there is a definition of data. Okay. Now that definition of data also gets applied to this law, because definition of data is only in Information Technology Act. Here it is been used separately. Now that says that any document which is printed out of a computer is also an electronic document.
Electronic document.
And any document which is meant to be used or meant to be processed in an electronic document is also an electronic document. See, it is easy to understand the printout. It comes directly out of the computer. Now, what is the data which is meant to be used? I used to earlier say, I may give examples of this optical recognition papers, where like your examination question papers, you put dark and white labels, and optical recognition recognizes what is the answer or something like that. We were saying that that is the example of a printed document meant to be used in a computer and therefore should be considered as an electronic document. Now, perhaps, if somebody has got a form and asks somebody to fill up name, address, etc., and there is a system in that company that this will be entered into the data space, then I can argue that this form is meant to be used for inputting into a computer. Therefore, that printed document where by pen I have entered my name and address is also technically can be called an electronic document. Okay. I'm slightly stretching the law, but in the absence of anything else, if systematically we collect the printed forms and then have a system of entering it into a computer, if that is an established system in an organization, I would argue that these two are related. Collection in paper form is meant for entering into the data registering. In fact, there are where we have today many softwares which may even read the handwritten thing and also take the input directly to the computer, whether it's accurate or inaccurate, it does happen. In fact, many of these application forms, bank application forms, has got squares or something like that. What is the meaning of that? I want one alphabet to be entered in each of these things because that is meant to be entered into a computer.
Right.
So, therefore, even though this says it is for digital personal data, let us not be complacent. Companies should not be complacent if they are having any paper document which is either generated out of the computer or paper documents specifically meant to be used for input into the computer. They should not be just thrown away and saying that I don't have responsibility for that. security should extend to physical documents also, like information security extends to physical security, like putting a lock. Now this digital data security should extend on either ways to the rendition of a digital data in paper form.
Great, sir. Thank you. So now the important element that is one of the much relief for the most of the bigger organizations or MNCs, that is a cross-border data flow. That is something which current bill, current draft bill is very specifically mentioned. It's kind of allowed. The data can be transferred to other countries, but only the condition is that the government will decide which countries we can, transfer the data. How you can look at this? Is it definitely? As far as we know, because we have so many cross-border, the things are associations are there. Recently, the UK is also given some kind of exceptions for something. So, how you look at this? Is it a benefit for us? Is it really protect the individual rights, whatever we say? But cross-border is one of the restricted. That is where the lot of discussions are happening now. This bill entirely, it is actually removed that kind of a statement. They're mentioned, yes, you can do that.
Right now, we cannot jump to any conclusion. What this section says is that, like you have adequacy in GDPR, government retains the right to declare X country, Y country as an adequate country. Okay. And once it is declared, then there is no restrictions as far as the transfer of data to those adequate countries. Now, what will be the criteria used for the adequate countries? You have to wait for the rules to come up. It may be as stringent as, say, EU. Now, EU has, of course, very stringent regulations, and they have actually added the BCR and SCC as additional measures by which you can transfer the data to a non-adequate country. Now, here government says that I will decide about the conditions for adequate country. They may classify the adequate country, if necessary, on class 1, class 2. I'm just speculating. So, okay.
Absolutely.
Where they may say that class 1 adequate countries, you can transfer freely. Class 2, you need to have a contractual arrangement. Therefore, what GDPR has brought in the form of a standard contractual clause may be brought in as a condition for transfer of personal data to adequacy level 2 or something like that. That is just, I feel that government will have its own way of ensuring that importance of data is recognized and data sovereignty is recognized. So I think let us not get too much overboard with the feeling that there is no restrictions on cross-border. Okay, there will be.
Also, we have to wait till the rules comes.
Yes, 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 true.
Right? Great. So now there is a question from our one of the attendees who is what the question is DPO, Data Protection Officer, necessary for every organization? And another thing is that whether it can be recommended like internal DPO has to be there or they can use some external DPO.
It's a good question. Of course, at present they have said significant data fiduciaries only require mandatory DPO. Okay, that's it is voluntarily if they want to designate somebody, that is fine. So a significant data fiduciary will require to do something additional to what others are expected to do. One of which is appointment of the data protection officer. Second is about the data auditor. And third is conducting DPIA, data protection impact assessment. These are the three responsibilities which they have mentioned are exclusive for yes, significant data fiduciary. Rest of the things like security, maintaining the accuracy, etc., is available for all. Now, the second question, which is whether it should be internal or external, right now, we have to interpret what is available. Okay, they have used the words, the significant data fiduciary shall appoint a data protection officer. They have also used the word that they shall appoint an independent data auditor. Okay, two things. This is section 11, okay, subsection 2. Now, when they say independent data auditor, it is very clear that he has to be an outsider. Okay.
Right.
So, but they have used the word appoint an independent data auditor. And same way they have said appoint a data protection officer. Okay. So I feel that in the earlier this thing, they had specifically mentioned that he should be an employee and he should be a KMP. Here, they have only mentioned that the data protection officer shall be responsible to the board of directors or a similar governing body. So whether that could be an advisor or he has to be an employee, I think it is slightly open as of now. If to be on the safer side, if we read the intentions of the previous bill into this, you see, whenever we interpret law, we have to look at the legislative intent, which is the jurisprudence. And jurisprudence is drawn from the previous discussions and other things. So if you look at it, perhaps the data protection officer has to be a senior internal person, whereas the data auditor should be an outside external person. That for the time being, I think we'll interpret it like that. Rest of it, we have to wait for the government to clarify.
Right. Great, sir. So since we're discussing about the data fiduciary and the significant data fiduciary, so I mean now most of the time when I'm looking at the data fiduciary within the brackets in most of the top newspapers they're mentioning, when it comes to the data fiduciary, they put up the bracket and they're mentioning media, social media companies and internet providers. So it looks like, is this data the significant? I'm talking about the significant data fiduciary means only these kind of a companies only supposed to become a data fiduciary as by the definition, because it's a larger volume of the processing data, or is it applicable? I mean, there is little confusion here. Most of the time
there is no confusion, except that government has been very clever. Now, earlier, the significant data fiduciary was only decided on the basis of volume of data. In fact, if you look, even ITA 2000, even now, has this significant social media intermediary. And for defining that, they use 50 lakh plus registered users in India as the threshold. Okay. So volume is the criteria there. Here, they have said that the significant data fiduciary may be defined either on the basis of volume or the risk of harm to the data principle, which was also there earlier, sensitivity of the data, potential impact to the sovereignty and integrity of India. This is new.
Okay.
And risk to electoral democracy. Now, Twitter's main contention is that they are having political opinion and security of the state, public order. These are considered as criteria by which you may define a fiduciary as significant data fiduciary, not only on the basis of volume and sensitivity of personal data. Therefore, the social media which you are talking of, if the government wants, they may declare social media of a certain nature as significant data fiduciary. I think that is what we should expect.
That's great. So other than that, now the consent manager, this is one of the things, even it was there in the previous, the bill also and current bill also. So generally, I mean, we want to understand like what is the role of that consent manager and generally who qualifies that? I mean, is that something that data protection board or the authority will identify these or the consent managers, or what we can expect from the next development in this?
Consent manager is a business opportunity for certain organizations. They have to register themselves with the data protection board, and registration means there will be a criteria, they will be accredited. Okay. And they will also be a data fiduciary. Okay, they will have the status of a data fiduciary.
Data
Now, but
fiduciary.
they are basically trustees of the data principles for the data. That is, these consent managers are not subordinates of another data fiduciary. Okay. So if some X company is a data fiduciary, it is using a lot of personal data, they cannot appoint somebody as their chela to say that you become my consent manager, you get the consent and hand it over to me. For example, this background verification companies and others, there are many of them they are doing. That will not be accepted. The consent manager will be an independent organization. On its own, it has to qualify as an accredited data fiduciary, get themselves registered with the authority or the board, and then they will represent the individuals, that is the data principles, for the purpose of giving consent or say raising objections to the for exercising rights if there is anything required. So they act as agents of the data principles, not that of the data fiduciary. So they have got a very important role in terms of as an intermediary, which say bridges whatever differences could be there between the individuals and the data fiduciaries. They will be the trustees of the privacy consciousness in India.
Okay.
And it's a great business opportunity according to me, but that company will be having volumes of personal data, obviously, and therefore their compliance requirements, security requirements are very, very high. Because they can be subjected to attacks from hackers and others.
Absolutely, because they are the custodians of lot of data, personal, the consents and everything. Yes. So the new thing came up in this new bill is the individual wise also. If the data principal, the obligations to the data principal. I mean, it was not there as per the earlier thing, but now there is a penalty also given. How you look at this? Is it not restricts the data principles?
That is the kartavya path for the data principles. Say, even our constitution is supposed to be having an article regarding duties of citizens. But we always speak about rights of citizens. We never even remember there is a duty of a citizen. Now, government is making us remember that data principles have some rights, but they also have the duties. What are the duties? Basically, if you remember, one of the things which you just mentioned about the media, it is also covered under these duties. That is, a data principal should not give false identity or something like that to any service provider. That is an important responsibility. Today, the bane of internet is there is too much of anonymization or too much of pseudonymization. Now, when internet was free and it was not being used for e-commerce, this was fine. But when internet became something which is used for e-governance and e-commerce and financial transactions, the need for identified transactions actually increased. That is why we used to say at that time we should have a different internet for commercial transactions where identity has to be there. Now, privacy people are trying to mix the two. See, my talking to you as an anonymous person in Twitter is something different. But if I have to do a financial transaction with you, you would like to know the details about me. And I also would like to know the details about you. So that kind of requirement comes because of the use of internet for commercial and financially important persons. So that is why now the data principle shall not provide any false information. Second, data principal can harass a data fiduciary by sending some innocuous queries. I can simply send one email to anybody, some Tatas or say Birlas or something, and say, are you processing my information? Please confirm. Okay, because right to access is there. Now, now that company will have to find out whether there is somebody called Vijay Shankar whose data is there in their data lake, and then find out where did they get that information, whether it was from a publicly available source, because publicly available source is in the deemed consent kind of a thing. So they have to establish that either to say yes or no to my query. For me, sending an email is very simple, but for the organization to reply, it costs money.
Right.
So and this kind of harassment has been observed in the past in USA. Something like, I call it as ambulance chasing kind of a thing. Somebody sets up a business saying that I am protecting the privacy of people, and they keep on sending notices to all the companies. Now somebody will send a notice to QRC and say, please justify that you are having or not having information about X, who is my client. Okay, they will take that client on the website and then shoot out a message for you. So that kind of harassment will now not be feasible, because if it is considered as a harassing kind of a thing, under the duties, perhaps the data fiduciary can raise a complaint and try to establish either 10,000 or even 1 rupee fine. Still, it is something which is necessary.
I agree. Because this is very important. This is really important point. Okay, so otherwise people misuse that act to settle their scores. Obviously. Okay, great. So now there is few questions actually we received on our Q&A section. So the first question from Bhavya. So the question is related to, if we are using a communication portal as a WhatsApp for communicating with the customers for any transaction details or the payment details. Like, it means something we are communicating to the customers by sending some transaction and payment details, whether which can be considered as a digital personal data. Do we need to take approval from the user mandatorily? So
say now the telecom bill also is defining the WhatsApp as a telecom service. Okay, even otherwise it's an intermediary IT service. Okay, under IT Act it is an intermediary. Okay, now we are all riding on that platform and making use of the platform for our use, not for WhatsApp's use. WhatsApp gives the platform, and I am using the WhatsApp platform for whatever I want to do. Now, if I am using it for business purpose, I may be transacting business information. That business information is not part of this law. But if I am using it for, say, personal information exchange, it does come under this law. Now, if you say WhatsApp is run on mobiles and there is a mobile information associated with every WhatsApp holder, still, if it is being used for business purpose or business transaction, the responsibility from data protection is very minimal. It is like your customer. See, if you are in a shop and a customer is buying something from you, you have to prepare a bill, you have to write his name there. Okay, but that is more than a personal a collection of personal information. It is actually for transactions. So there is a right, legitimate right for you to collect that personal information. And there is also a deemed consent. If you have floated a WhatsApp kind of a group and ask somebody if they are interested, they can join the group for such and such a purpose. And if he joins it, there is actually a deemed consent that his mobile number will be known to you with your name. Because nowadays mobile numbers will come with the name and KYC. That is what the TRA is going to do. So that much of information will come under deemed consent.
Great. So another question, I think this is somebody is asking Mr. Paresh, how this bill is different from existing regulations for Indian banks operating, have regulatory requirements for handling, processing and erasing data. So I think, Mr. Paresh, I think this is when we are talking about the banking regulations, which is already there for handling, processing, erasing data, that is mostly for the payment transactions data, not with the personal data. So that is I can see the difference between these two. The question is, because banks are already following certain data, the regulations to processing the data, and what is the difference between the digital protection bill and that regulatory things. That's what actually the question. So I guess according to me, because the banks, when they're talking about the data, it is more like the transaction data or the payments data. This is what actually the data localizations and everything they are talking. But when it particularly comes to the digital data protection, it is more like a digital personal data, how we can protect. And also it emphasizes generally the banking regulations, they never mention the rights of the data principles, okay, how to protect. But here the Protection Act is much more on the providing the just now what we are discussing. There is a consent management, there is a the data principal rights and etc. This is how this is different than the regular banking guidelines. The third one, I mean, yes, this is a question for you, Mr. Navi sir. This is, can we make recommendation? Can we make recommendation on guidelines for security measures of data processing from FDPPI? It may be good idea to document this and share. I mean, this is
No,
someone is
certainly
recommending.
we are going to do it. First of all, we are going to submit our say comments as a part of the public, which has to be provided before December 17th. Okay. Now, anybody who wants to lodge their views with FDPPI, they are welcome to do that. We will consolidate it and we will submit it. But this time, government is not going to publish the comments received. They will just receive it, go through it, and perhaps take a decision. Previously, they used to put it up also on the website, so we were able to know who has given what recommendation and other things. So that is done. Subsequently, once the data protection board comes into being, organizations like FDPPI will continue to be in touch with them and keep giving our viewpoints like a shadow DPB. In fact, that is what our aim is. In fact, we have even today, we had started working out sectoral guidelines for different sectors, and we wanted to prepare the kind of guidelines which the government is mandatorily has to do. We are not authorized to do, we are not required to do, but we will do it. If say some guideline is required for the industry, we will try to develop a draft and we will push it to the data protection board. I'm sure that they will also have an opening for receiving such suggestions continuously, even after they start working. So we will definitely do that. There is no doubt about it. You are all welcome to contribute to this kind of an activity.
Right. So there is one question regarding the consent. I mean, one is some kind of a deemed consent. That's what actually they mentioned. What is this? Any example? Where we can consider as a deemed consent? And another question related to the employment data exempted from explicit consent. How we can see this?
Say, in fact, I actually consider that as a good provision for most of the organizations for two reasons. One, employees are trusted people as far as the organization is concerned. My strengths and my weaknesses are known to my employees. So whether I'm having appropriate data protection, whether something is right or wrong, my employees are actually part of my system. If something is not good, they are also responsible for that, not only the owner. Okay. So that being a closed community, they cannot be equated to the public. Say in GDPR scenario, what is happening is an employee who is actually retires, or sometimes he goes out of the organization because of friction, he becomes the biggest threat to the organization. He need not commit a fraud. See, earlier we were looking at it as a fraud risk. Okay, an employee knows about the password systems and other things, so he may commit a fraud. Now, he can simply drop one letter or email anonymously to the Data Protection Authority and see that the next 1 month, your company is getting into all kinds of, frivolous problems. So like people post on Glassdoor or something like that, employees could cause various issues. If it is genuine, I have no problem. Then everybody has to answer. But many times it may not be genuine. So therefore, employees need to be treated as somewhat different from the public. Now, what this deemed consent says is that anyway, you are going to have an employment contract. Now, employment contracts do have certain privacy related issues. You may call it as an NDA, but basically confidentiality of information is there. Now, in return, you have to get the employee information. See, the problem will mostly come about behavioral monitoring of employees. See, every organization needs to monitor the behavior of employees from information security perspective. As a security person, I even tell people that you have to know what your employee is doing outside the office. Now, if an employee is going to spend a fortune outside the office, which is beyond his known sources of income, which I am paying as salary, that is a red flag for me. So people like us have been telling that there is a need to monitor employees both inside the organization while they are working as well as outside. It is both a reputational issue as well as the security issue. So therefore, we need deemed consent. So deemed consent covers employment like background verification, onboarding, and then maybe during the course of employment, you take biometrics for attendance and other things. All these things are now covered under deemed consent. So to some extent, employees should be much relieved by this. Otherwise, every employee is a big threat from the data privacy issue.
Navi, if you remember last time when we have this training, we discussed the same point, because how it is, impact every organization in the country, right? Okay, great. So this is question like, the QRC kind of a, organizations being a certification body for various standards. So here also there is a role called data auditor. So, but they mentioned only the data auditor supposed to perform some specific audits after this bill is passed. So what is there any specific certifications or the qualifications is required, and who will define this? I mean, is there any body which defines you are the qualified auditor to perform this privacy audits as per this bill?
See,
Can we anticipate something?
the only organization which is capable of setting standards is the Data Protection Board.
Right.
And this data audit is not like a statutory audit or say another information security audit. So the Data Protection Board cannot simply say that if you are an accredited certain auditor, you will automatically become this auditor. If you are a chartered accountant, you will also become this. I think they cannot do that and they should not do that. Okay. Though some of these professional organizations will try to bring their own pressures on DPB to say, if somebody is a certain accredited auditor, let us call him as a data auditor. But certain audit is different and data audit is different. Data auditor has to look at every compliance requirement and measure it along with what is required in law. Sometimes he has to take interpretations and he has to also look at international law, what are the norms and other things. And this, he has to conduct what we call as a techno-legal examination of every processing policies which the company adopts. And that is something different from the other known auditors. So Data Protection Board may develop their own norms and accreditations. And they may even, if I'm left to decide for them, they may even put up an examination of their own, like patent consultants have to pass an examination done by the patent board. Likewise, a data protection board may have its own test given to people to understand whether they are good for data audit. A good data auditor should know the law as in India. He has to know the law abroad, because many times we have to say GDPR says something like this. So should we use that or should we not use it? Either way, we have to analyze. Okay. So he has to know the laws of India, laws of other things. Now, GDPR is not the same as CCPA. It's not the same as Singapore. So there are multiple types of data protection laws. If you take the West Asia, you have got a DIFC DPL, you have got a UAE data protection law, you have got an Abu Dhabi law. Now, this person should at least have a good working knowledge of all such laws so that he can interpret certain things from there and look at whether a company is doing properly or not. And many times organizations have mixed data. That is, they have got data from India and data from elsewhere. So data processed in India, I have to look at the Indian law. Data may be processed elsewhere. I may have my own other processing centers. I may have to have different kinds of laws. So this is a kind of a specialization which has to be developed. In fact, FDPPA has already been doing this for the last 3 years. We are creating certification programs in which one module is on Indian law, one module is on global law, and another is on data audit skills, like what is DPIA, how to conduct it. At that time, we had this privacy by design policy. Now it is not mentioned by name, privacy by design, but still it will be required. So this data auditor needs to have technical, say, appreciation of what his organization is doing and the legal knowledge. He also has to be a grievance redressal expert, because the grievance redressal is a right now given to the data principal, and the first grievance redressal officer is the DPO, and he has to also put up an ADR process, alternative dispute resolution mechanism. Now you should ask many of the IT people, do they know what is ADR? Now that is there now in this new law. So now in my training, I have to add ADR. At least people should know what is mediation, what is arbitration. Who can be a mediator, who can be an arbitrator. Then only it goes to the court and other things. So therefore, the data auditor's responsibilities are much different from the responsibilities of many other known persons who have the tag called auditor. The auditor tag should not be confused with a chartered accountant is an auditor, is a statutory auditor. This is a data auditor who is different. You should look for appropriate skills to be acquired. As I told you, FDPPA is one of the organizations which 3 years back we started, because we knew this is going to happen. So let us see, other organizations also will perhaps start, and that becomes a requirement of the marketplace.
Great. Thank you very much, sir. Most of the questions we answered, and just we left with 1 minute. So just I want to summarize. So overall, it was a good session and knowledge transfer session. I hope people hope enjoyed learned something out of this webinar. And look at that overall, whatever our discussions and the current bill, it seems to be, I mean, it's a lot of exemptions as given, and as well as it make it very such a simple, simple terms, it is made that complexity is remove the complexity out of the previous bill, and it is a much more simpler to understand the things. And also the kind of business point of view, whether it is a cross-border, whether it is a anonymized data, non-personal data, these are certain things they remove. So it should be widely, I guess people will accept this as it is, because all the little debatable points or the clauses actually have been removed. And also the data protection board, we discussed what is their responsibilities and who will be the what is the responsibilities of the consent managers. And I mean, we touched that who will be the data editor. As you rightly said, it might not be that easy, like all the CS can become a data editors, because that is a set of different, they should understand the fundamentals, rights of the privacy, not only from Indian perspective, even outside laws and regulations they should know. And also we discussed about the penalty clause. That is something very new. Yes, we fully agree with you, that kind of a little bit of the kind of a things needs to be there, like otherwise people will misuse that act for their own benefit. And also very important, the digital personal data, that is one more important element we touched upon. And also we discussed about the exemptions part also. So with this, I guess overall, I mean, one more last point is that, earlier the penalty clause, which talks about the turnover basis, but now it become like minimum $250, crores to 500 crores is the limitation which is the given instead of the overall turnover of the organization. That is also some relaxation for the organizations, right? So I guess overall the seems to be very nicely made, and we will look forward the final the more detailed rules once the bill is passed. So I hope definitely it will meet all the expectations from the stakeholders, also the citizens of the India. Thank you, Mr. Navi, for taking this, giving us an opportunity to take some session from you. Thank you very much. Have a nice day, sir.
Thank you.
Thank
Yeah.
you.